Good to have you, Aisha Yesufu. It's a joy to have you on the show this morning. So let's start.
Thank you so much. It's a pleasure being here.
Good. Let's start from the very beginning. The outcome of the Presidential Election Petitions Tribunal, PEPT, as it is called. The judgment is interesting, and it's divided quite a few Nigerians. So help us understand, because I noticed you were there at the petition tribunal. What's your opinion, or what's your thought about the outcome of that presentation? 13 hours plus long, where quite a few people were dozing off and nodding off. I don't know whether they did snore, but I was wondering, what's your thought? You stayed awake throughout.
Oh yes, I did. Nobody, I don't think I heard any snoring, so that wasn't a part of the whole proceedings. But there were quite a lot of people who did doze off. It was quite tiring, you know, just sitting down and just listening. I was there to actually listen, and I paid rapt attention to the whole proceedings. And I'll tell you, overall, just listening to the judgment being read out, and it was disappointing, not even about the outcome, but one, in the way that it was being read, two, in the kind of mannerism, in the intonation, in the kind of words that were being read at. And I will tell you that was my first time of being at the sitting where judgment was being read out in such a manner. And I was expecting, you know, those play of words. I've read certain judgments, like, you know, reading the ones of like Lord Denning and all of that, and what they've said about words. So that in its own way, just listening to it wasn't as interesting and one would have wanted it to be. But that's by the way. On the whole issue was the fact that the judges, in my own opinion, and I'm a witness because I was directly there on that day, is that the justices sounded more like counsels to the respondents than they did like justices. And I know a lot of people have been saying things like, oh, do you think they will charge you contempt of court and all of that? We have opinions. I must air our opinions. When it came to issue of the judgment, when it related to the petitioners, you could almost feel the anger. The body language was like angry, the intonation, the words that were being used. Do you think we're going to go to the market and go and get evidence? Things like, oh, you think to come to court and prove that there's an election malpractice or rigging. You think it's like drinking, is it coffee by an Englishman? They said, you know, all sorts of the way it was being done, almost as if the court was angry that there were actually people who had come to question the election that took place. And in terms of the conversation being had, in terms of the judgment, where you saw, it's almost as if INEC did a sterling job, that there was nothing that INEC had done wrong in all the things that it did. But one other thing that I found most peculiar was when it came to the issue of constitutional interpretation, where when it came to the issue of the forfeiture, the judgment was just read. You know, it was just clipply, as if there was nothing on it, and they just passed over it. But when it came to the 25% of FCT, that's when they would tell us that, look, the Constitution is a living document. You don't just literally, you know, put out the meaning. You don't use literal interpretation to just give an interpretation of it and all of that. And I'm wondering, when it came to the forfeiture, why was that such effort was not also put in place to say, this is not just about now, this is not just about a document, this is about the generation that we have right now and the generation that are yet to be on board, that it's actually a living document. So that kind of, you know, it's almost like there's a difference when it came to issue that needed to be responded to. And for me, I just felt there should be, people should see that unbiased stance from the justices. Also, to also add the fact that there was live coverage of the reading out the judgment. they, of course, didn't want their faces to be seen. They had warned the media about that the faces shouldn't be shown, only when they were coming in. And then I wonder, why was there no live coverage when it came to the time where there was going to be the trial itself, where evidence would be brought in, so that Nigeria's people, the world, will be able to see what really transpired in the court, as against just seeing the judgment that was read out that day.
All right, then. Thank you so much for setting the tone of the conversation. And I appreciate the fact that you were live in court, so you were able to see things that I guess the rest of the country wasn't able to. But when we talk about the court noting procedural blunders by the petitioners' legal teams, including failure to file witness statements on oath as required, the court also highlighted paragraphs of the petitions that they deemed vague, imprecise, and generic. The court also emphasized the lack of credible evidence presented by the petitioners. Now, are we seeing how these procedural errors impacted the outcome of the case? Some are saying that the justices did a thorough job, to the extent that even some of the senior lawyers representing the opposition parties were chided for their inadequacies to look into their research to build their clients' cases. Are we looking at maybe a situation where the opposition's petition was watery from the beginning? And especially when we look at that in the backdrop of them going to the Supreme Court, they are not allowed to add any more information, any more witnesses. They are taking that same case to the Supreme Court. Would you say that maybe it was a case of the petition being watery from the beginning?
Well, the thing is that for you and I now, because we're not allowed the live proceedings, I wasn't in court all throughout the trial. So I came in, I wasn't in the country, so I was able to attend the one of the judgment. So first of all, that's why they say when you're talking about justice, it must not only be done, but it must also be seen to be done. And one of the things that all of this conversation would have cleared would have been when citizens were making demands that there should be live transmission from the courts during the tribunal sittings. If that had been out, every one of us would have been able to see this watery evidence that were put in, or watery case, or whatever the name that it's called, that was put forth. But first of all, that wasn't allowed to happen. And then it is a judgment where it is justices now saying this is what they have arrived at that was allowed to happen. Apart from that is also the fact that there is where they said the way and manner in which INEC had been served in terms of getting the evidence, the materials they were supposed, the counsels to the petitioners were supposed to have access to, that they didn't get it. One of the things that we also have to look at is that the court gives instruction, the court gives its orders to INEC, and then INEC doesn't fulfill it. And at the end of the day, we've seen the court just not doing anything about it and just moving it. And this is not something that is just peculiar to the issue of whether it's INEC being asked to allow petitioners' counsels to have access to certain materials. And I could say we're also where amongst the justices, when they were reading out that judgment, where they said that, I think it was Justice Haruna Samani who had read out on the fact that any credible candidate should not rely on INEC for their results and things like that. We've seen time again and again where courts in Nigeria will give order, either the executive or institutions will not obey these orders, and it's almost as if it's business as usual, and they just continue what they're doing without really looking at it at the fact that this is an affront on them. It's one thing for us to talk about technicalities and all of that, but it's another thing for us to say there were people, the people who were on the petitioners' council, there were a lot of sons there. There are people who had, this is not their first time of doing a trial, election petition, and for say that all of them, every one of them, that they didn't file these things the way they're supposed to be filed. I'm not a lawyer. Probably the lawyers will be the ones to answer that. But what was most instructive was the fact that the whole justices seems to be on the side of the respondents more than they were just being neutral. And for me, just being, even in the court, the body language, the words, it's almost as if they came alive whenever it was issue of the petitioners that were being discussed. That's not the way it's supposed to be. And I think it was Lord Denning that said that the law is supposed to be there to protect the weak and not to protect the strong. And we must begin to, and for me, that's why over the years, and this is not my first time, and it's not because of the result of what has happened, but the fact is that we need to begin to look at the independence of the judiciary and let us know, do we have, the way we have state capture, do we have also a judicial capture, do we have, how do we, the things that from all of this that we all need to be asking ourselves is that, how do judges get into office? What is the process that bring them in? Is it a transparent process? Is it a process where it's plagued with nepotism and all of that? And at the end of the day, how does it constantly affect the judgment that come out of the courts over time? And we've seen a situation in Nigeria whereby people go on judicial rulings shopping. So somebody will leave Imo State and go to Jigawa State because they want to be able to have judgment in a certain way. Someone will leave Kano State and go to Edo State because they want it in a certain way. What are the things that are leading to all of this? You find a court of appeal in one state, on the same matter we give a ruling, another court of appeal in another place, on the same matter we give a ruling. And so that confidence that Nigerians have in the judiciary, even before the presidential election tribunal started, a lot of people were not interested. A lot of people say, oh, there's nothing that is going to come out of it. We know how this thing. And I remember constantly saying that, look, it's not our business to trust the judiciary. Our business is to overwhelm the judiciary with evidence. And so these are issues that we must ensure that as a nation, justice must be seen. And even in the case of INEC, it's about the processes, it's about the procedure, it's about the things that need to be done. And if these things are not done, we will continue to have a country where people will not have confidence in the government.
Absolutely, absolutely. At that point is where I really want to take it, overwhelm the judiciary with information. And let me take a back step and go back to my own younger days. 1983, the first and only time in my life that I decided I wanted to work for a political party, and that was the Nigeria Advanced Party, NAP, organized and put together by Dr. Tunji Braithwaite, because it captured just the way the obedience were captured. A lot of young people in 1983 were captured by Dr. Tunji Braithwaite because we just believed in his desire to change things. So we joined. And the reason I'm making reference to this was because I was one of those who were polling agents for Nigeria Advanced Party in 1983, and we were able to get copies of all the results and everything and put it together and went to Yaba, coordinated. I was in Illegitimate, then coordinated and sent all the information. We didn't get a lot of votes. But Peter Obi and the Labour Party seem to have gotten a